and he has more than 5 years teaching experience. He has worked as assistant professor from July 2014 to 2018 in Siddharth Law College, Dehradun. At present, he is working as assistant professor at IIMT University. Mr. Sandeep sir, I welcome you, sir. Hello, am I audible? Yes, sir. Mr. Sandeep sir, I think there is some issues at some end. He's not able to hear me. Let's wait for 2 minutes. Uh, Sandeep sir, are you here?
Thank you, ma'am. Thank
Yes, sir. Good
thank
morning,
you,
sir.
ma'am. Good morning, ma'am. Am I audible, ma'am?
Yes, you are audible. So it is over to you now.
Thank you, ma'am. Thank you. Thank you, Dean, sir. Dr. K.D. Sharma, sir, making me speaker for the Faculty of Arts and Humanities. And thank you, ma'am. My topic is on online infringement of IPR. And firstly, we
Sandeep sir, you are not audible. Your mic is mute.
now it's audible, ma'am.
Yes, sir.
The ability to distribute copyrighted work and content in digital form through internet-enabled transmissions has brought new challenges to the protection of such content and information from unauthorized users from use and copying. Of all the achievements made in the 20th century, the development in information and in communication technology to nearly all aspects of our life, fueled and driving its most potent arm. The internet, it has not only created electronic marketplaces with new opportunities and incentives for the users and non-users alike, but it has also sparked new wave of apprehensions and challenges such as data protection, digital rights management, and protection of intellectual property, etc. The rapid development taking place in ICT, that is information communication technology, has made it possible to convert all phenomena into digitalized information, which can be shared and exchanged by people all over the world by means of computer network. All as this use of computer networks further a somber realization downs up all that technology is a copyright industry's best friend and worst enemy. Much depends on the way new facilities and technological innovations are used. The widespread use of computer networks, especially post to post technology, that is P2P, have made it feasible for recorded musical works, video and video files to be transferred over telephone lines from one homes and offices. A person of any age group can easily listen to, watch, and download any music, movies, or software, and that too remuneration. These who will be freely disseminated over the so-called information ensuring that the people who the artists, the musicians, the producers, and the distributors get fair share of users every time a user obtains their piece of their work. The matter and mass of the internet is growing just like that of our universe by each passing day. Each new technology that has taken a new shape gives rise to a new set of legal disclosure, leading to a flux in our laws. The digital platform, like that of the internet, is a place where we encounter never before seen interface of various facets of our lives, like that of privacy, etc. And all of it ultimately poses us with questions like what rights are available to us and what aren't. Internet undoubtedly has been a free space nurturing ideas since its inception. So with ideas come the notions of protections of them. Now coming on to file sharing network, the evolution of peer-to-peer technology. So now we have to understand what is file sharing network. Online file distribution was first effectuated through the client-server model and then through three types of key, that is P2P platforms: centralizing indexing, local indexing, and super node indexing. Attempts at creating file sharing networks began in mid-1990s began to toy with the to handle much accessing website, a client server file sharing program simply allows the client to retrieve the were vulnerable to heavy traffic inflows and would collapse under mounting requests to the server. The user subsequently runs the program. The software connects to other users and allows the users to search though other users shared files for ones the user would like to copy. In, in this manner, members of the network are able to access and share files from other users all over the world. And this is the modern phase of P2P networking. This hybrid scheme tries to capitalize on the performance advantages of the centralized indexing model without succumbing to some of the pitfalls to total decentralization. The convergence of technological innovations such as MP3 audio compression, high-speed internet connections, and peer-to-peer technology has changed the way music and other information is distributed in the digital age. Millions of users are now enabled to connect music and other media files so simple that even those with little internet savvy have quickly adapted. But despite the obvious benefits, the fact remains that the copyright holders did not grant legal permission for the media to be shared. In file sharing, while users may have initially legitimately purchased media, they are sharing their rights in that work do not extend beyond their own, not allow the user to and also sell or otherwise transfer the file. What makes the file sharing so popular and yet so hated at the same new generation of net users? The argument that these networks only facilitate the piracy often overlooks one simple fact that it is people's actions that constitute the piracy. Piracy requires people see file sharing as permissible. Piracy would drop off dramatically if enough people came to see file sharing as more. But the catch remains that would people see file sharing as morally wrong. At the end of the day, the proponents of anti-piracy manure must remember that if file sharers do not see the benefits of compliance, they do not they lose the ability to use music in a way the same natural to internet users. The internet, after all, was meant as a tool designed precisely for this purpose. The gap between the legal and the social norm is that a large percentage of internet users have not and are unlikely to internalize the prohibition that the music industry is trying to enforce, and in majority of cases, enforcement will actually further reduce the perceived benefits of compliance. It was possible to express this belief credibly in the early Napster days. Since recording industry sales began there in 2001, however, one hears this viewpoint expressed. It is nevertheless worth monitoring here, because even if the rationale is now discredited, it may nevertheless have been formative in bringing about the permissive norm. This attitude transfers norms property applicable to physical objects to the realm of intellectual property rights. There are a sizable lot who still feel that the concept of intellectual property rights actually dilutes real property rights, in that an intellectual property owner can actually limit. Now, coming on to infringement of copyright laws, what are the infringement which will occur in the market of copyright infringement? We have just seen that illegal digital file sharing is difficult to store because of the social norms held by the people that file sharing acceptable despite the existence of copyright laws. The internet is unregulated, and that is lack of regulation make the copyright to the problems created by digital file swapping with its small cost of application and distribution has caused an uproar from the copyright industry. Today, no other substantive area of law is faced with a greater challenge than copyright of musical composition and sound recordings in the modern age. It needs to be analyzed under the existing legal whether under the existing legal regime, the rights of the copyright holders are effectively protected or not. Whether our current system of corporate law is capable to deal with the onslaught of file sharing. The question is important because file sharing technology may undermine the effective protection offered by copyright. Now, legal regime say Article 1, Section 8 of the US Constitution gives Congress the power to grant exclusive rights to inventors and artists for the purpose of advancing science and the arts. Federal copyright law is codified in Title 17 of the United States Code, and federal judicial decisions are designed to protect the exclusive rights copyright owners have in their works and to provide remedies when the rights are infringed. These exclusive rights are enumerated in Section 106 of the Copyright. On these exclusive rights are covered in Section 106. There are three principal ways to establish liability for copyright infringement. That is, point number one is direct liability. Point number two is contributory liability. And point number three is what is direct copyright infringement. Direct copyright is covered in Section 50 Copyright Act. A person directly actions he violates of the allegedly infringed material and a demonstrated violation of at least one exclusive right granted to under Section 106. Under Section 106. Another potent legislation to deal with the challenges of digital technology, Millennium Copyright Act passed in 1998, that is DMCA, addresses the liability of the online services and internet access providers for copyright infringement occurring online. Subsection 512 subclause A of the DMCA exempts qualifying service providers from monetary liability for direct, vicarious, and contributory infringement and limits injunction relief. Subsection subclause A limits liability for infringement of copyright by reason of the service providers transmitting, routing, or providing connections for material through a system or network controlled or operated by or the service provider. If five conditions are met, these are what are called as safe harbor provision of the Digital Millennium Copyright Act, that is DMCA, are one possible argument for the legality of P2P networks. The claim therefore is that Subsection 512 subclause A protects their core function of transmitting, routing, and providing connections for sharing of the files its users choose. The DMCA is certainly a step in the right direction in terms of updating American copyright law in order to better address the piracy issue that will exist as technology continues to improve. It still does not solve the problems that the file sharing on our diffuse private level presents. Furthermore, while the DMCA takes aim at digital piracy, it does not focus on the issue of individuals who are infringing without using unique circumvention technologies to reach that goal. Now, legal regime in UK, as we have understand the USA procedure, now we have to understand the UK and then for India. Now in UK, there is a CDPA, that is Copyright Design and Patent Act 1988. It creates a statutory property right with respect to various work of authorship. The property entrusted granted by the act gives owner certain exclusive rights that differ depend type of work at issue. These include the right to copy the work, issue copies to the public, perform, show or play the work in the public, broadcast the work or include it in a cable program service, make an adaptation of the work or to do any of the above in relation to an adaptation. The act explicitly labels as an infringement like situation in which a person directly or indirectly does or authorizes anyone to do what which the act recognizes as the exclusive right of the owner. The CDPA provides for a number of defenses under Chapter 3 that serve to exculpate uses of the works that would otherwise represent infringements. These exceptions include fair dealing of the purpose of research, private study, criticism, review, and news reporting, that is Section 29 and 30 will brief. Various educational uses that is defined under Section 32 to 36A. Use in connection with library archives, Section 37 to Section 44, or public administration, that is defined under Section 45 to 50. Thus, unless one of the available defenses is engaged, both parties involved in the sharing of a copyrighted file through a P2P network will be found to be infringing the applicable copyright interest at the very moment that the file is or that is made available for download. Now coming on to legal regime in India, that what we have now, we have a Trademark Act 1999, Copyright Act 2000, Design Act 2000. So we have to understand the legal regime in India. Though the sharing of a file on a digital platform can lead up to two-way liability, as we have seen above. In India, the two liabilities are, that is, liability of a sharer and the liability of an intermediary, is dealt with two separate statutes. The formal liabilities deal with the Copyright Act and the latter deal with the Information Technology Act. Thus, creating an interface of the two, the liability of the person who uploads the content would be in the direct contravention of the Copyright Act, and the liability of the intermediary who provides the platform for such provision of Information Technology Act. The Information Technology for the intermediaries, such as point number 1, the function of the intermediary is limited to providing access to a communication system over which the information made available by third parties is transmitted or temporarily is stored or hosted. Point number 2, the intermediary does not initiate the transmission, select the receiver of the transmission, select or modify the information contained in the transmission, or see that intermediary observes due diligence while discharging his duties under this act and also observe such other guidelines as the central government may prescribe in this behalf. Now, on concluding my topic of infringement, one of the common proposals for how to end problems of online infringement of by sharing file is to use a technology called digital rights management. Digital rights management allows entertainment industry to package their products in the ways that prevent purchasers and other parties from making undesirable use of the products. The advanced technology contained in the product allows the copyright owner to take control over how the purchaser handles the property. Although this type of programming may help decrease the problems associated with digital file sharing, digital rights management infringing on fair use, and is too limiting as a solution to digital file sharing. In a more practical sense, digital rights management also is not the optimal solution to the file sharing problem because of these reasons. That is, it is likely that there will be someone who can hack the protective fence. Point number two, it is likely that the public reaction towards digital rights management strong arm tactics will ultimately harm the industry more than help it. Furthermore, the public is vocal in its aversion to digital rights management, and it cannot continue to make money by alienating its own customers. However, digital rights management still remains a viable model to be tried. How to make blatant and cheap violation. The copyright infringement issues of the digital age knows no borders, because an infringing activity does not stop at jurisdictional boundaries. Any agreement must be reached with an eye on the world as a foster artistic achievements to an extent never before reached. Educational initiatives related with infringing behavior also serve as a practical solution to privacy. To be successful, we must overcome the current consumer mindset that there is nothing wrong with downloading music as a victimless client. The record industry should making a speaker conference on me as a speaker.
Hello, Sandeep sir, your mic is mute. Hello, am I audible?
Yes, ma'am, you are audible.
Ma'am, please check. Sandeep sir's mic is mute. Are you able to unmute it?
Ma'am, he can unmute himself by pressing the unmute button on the screen.
Thank you,
Okay,
ma'am.
ma'am.
Thank
Okay.
you.
Okay, sir.
Hello.
Audible, ma'am.
Sandeep sir, thank you
Yes,
so
ma'am,
much
yes, you are
for
audible.
your valuable words and knowledge. We all are benefited by it. Thank you so much, sir, for your valuable time and words. Thank you so much.
Thank you, ma'am. Thank you.
Okay. Sir.